Hi, this is Andrea Kane, and I'm here with you for HIT 421, Legal Aspects. We are on week 2. If you take a look at your syllabus, you'll see that this week we'll be covering chapters 3 and 4, and that is still focusing on unit objectives 9.1.1 through 9.1.16. If you'd like to follow along, this lecture video is just on chapter 3, and we're starting on page 33 in the textbook. So right off the bat, let's talk about our legal system, public versus private law. In public law, you're always talking about the government being a prosecuting party. So make sure when you think about public law, it involves somehow a relationship between individuals or businesses and either the federal, state, or local government. A government representative is a party prosecuting the accused individual or business. It may be criminal law if it's violating a criminal statute, or if the regulation violation is so bad it's reached a criminal level. That would be criminal law. Civil law, again, the government's prosecuting, but these are regulations that have been violated, but they're not criminal in nature or to a criminal level. So it involves civil law. But make sure you know that when it comes to public law, whether that's criminal or civil, the government is involved in prosecuting. When it comes to private law, that is between people or among private businesses. The government is not involved. So an example of criminal public law would be a murder trial. An example of a civil law would be the Office of Civil Rights prosecuting an individual who has deliberately, intentionally violated HIPAA and perhaps sold a patient's confidential information. If that patient's a celebrity, they can go after them on a civil basis. Private law would be, for instance, divorce situations, property disputes. It might be contract issues where two businesses, one feels the contract has been breached, the other one says, no, we haven't. So you have that with private law. It's not involving the government. Public law is, it's either criminal or civil, but the government is involved. Constitutional law is that deals with the types of power and authority that governments are given. So I think we all learned this way back in grade school days, that the U.S. Constitution provides for 3 branches of government: the legislative, executive, and judicial. And constitutional law looks at how each branch functions, the things that they do, the laws or rules or regulations that they are proposing, or that they pass, that are being challenged, and things like that. Also with the judicial, the way that the Supreme Court can look at it for the judicial branch is, did a lower court make an appropriate decision in line with the Constitution? So constitutional law usually ends up in the Supreme Court, but it can be done in a lower level case. But it's always going back to what is federal law, what is the Constitution in terms of how power and authority is being handled on a governmental level. Statutory law. Statutes are enacted by a legislative body. That could be by a state, or it could be by the federal government. You can go out and look at U.S. Code. That's a compilation of all federal statutes. You can go out to your own individual state, which for us, most of us here that we're talking about, is Iowa. If you live outside of Iowa, or you have lived in another state, you can always go to that state's website and take a look at their state statutes. These are what their legislative bodies have stated is their law, their statutory law. Then you also have administrative law, and this is the executive branch that's enforcing laws enacted by the legislative body through the development of rules and regulations. And again, administrative law can happen on the state level, or it can happen on the federal level. I'm just touching on this briefly because we need to get through this information, but in terms of what we're learning in this class, it's really pretty minimal. in terms of what you will actually run into in the real world outside of school. So I'm not putting a whole lot of emphasis on this, just more for your own personal knowledge and background and context. So getting back to this, because we do talk about federal regulations, and we talk about going out to the Federal Register to look at federal regulations that are published on an annual basis. So in that case, you do need to understand that that is administrative law. It is taking laws that were enacted by a legislative body, developing rules and regulations, and kind of explaining or clarifying the law that was put into place by the legislature. Now it's the administrative or the executive branch, their job to carry it out. And how do they do that? That's through rules and regulations. So you'll hear us talk about, we have to go out to the Federal Register. We have to see what the federal regs are for the coming fiscal year, government fiscal year, when it comes to coding and compliance and things like that. Common law. This is judicial law or case law. These are decisions. Common law comes from previous court resolutions of disputes or precedent. What has already been determined in lower courts a lot of times ends up applying to decisions in higher courts. So you see this. Some outcomes on the resolution of disputes vary from state to state or from federal court system to another. When there are disputes in common law, which is judicial or case law, a lot of these do end up going to the Supreme Court for clarification. And sometimes the Supreme Court says, oh, we're not going to consider that case. We're going to let the decision stand. Stare decisis. There's already precedent for that. There's no need for a higher court to go over that again. It's clear that the lower courts have determined this, and there's not really any room for the Supreme Court to work on this topic. So that might be an example of where precedent is allowed to stand and it becomes common law, and that everyone respects it as a decision-making outcome, rather than it was something that was done through a legislature or that type of thing. And then, so that is what is behind that. There are conflicts of laws. State to state is a big one. We talk about that quite a bit in HIT because every state is different. And when we were talking about HIPAA, we talked about the fact that HIPAA came in, and HIPAA was the first time it basically said to all states, we don't really care how good or how bad your privacy, security, state laws are. We're going to lay down a minimum, and you have to meet this minimum. If you're a good state and you have great laws and you have been very specific and they are better than our federal HIPAA law, then you get to keep yours, and yours will take precedence over ours. And meaning that everyone has to follow your laws, not the federal HIPAA laws, because your laws are even more strict, more detailed, have higher requirements to them. However, if you're not so good of a state and you just kind of didn't really have much out there, or what you had you didn't clarify, there weren't a whole lot of details, it wasn't specific, maybe it didn't even come out and say that people had rights when it came to their health information or how it was to be protected, or the fact that you didn't really go into a whole lot of detail about retention and how things should be retained and how they should be destroyed and all of that, the HIPAA came out and said, well, you know what? You haven't got much. In fact, you haven't got enough. And so HIPAA's now here. We are more stringent, more strict. We have more details than what your state does. And so you are required to step up and follow all of our rules rather than what your state says. Another example where states vary is you get to licensure of nurses and doctors and people like that. You get to licensure about cosmetologists, licensure about massage therapists. It all varies state to state. They have different laws. One state may regulate bowling alleys. Another may regulate gambling facilities. Another one may regulate, I don't know, anything that's entertainment related, like movie theaters or regular theaters, where you would go see a live play, or they may get into other types of venues or other types of um, businesses or services and that they regulate. It just varies state to state. And then, of course, you have varying laws between the federal and the state, and HIPAA was a good example of that, where the feds basically came in and said if your state law regarding privacy and security is not at least as strict as ours, you're going to have to use ours. We become supreme. And in most cases, that is true, that federal law trumps state law. When it came to HIPAA, they did say that if the state law was more strict, or the word is stringent, than federal HIPAA law, you would follow your own state laws. So, government organization. I think everybody's heard of the three branches of government. There's the executive, the legislative, and the judicial. And the executive branch responsibility is to enforce laws through the creation and issuance of rules and regulations by administrative agencies. So the executive branch does not pass laws or create laws or judge laws. They simply enforce the laws by coming up with rules and regulations through the administrative agencies. A good example of this is CMS, the Centers for Medicaid and Medicare Services, Medicare and Medicaid services, and how they roll out any federal regulation of healthcare. They are the ones that come up with the rules and regulations. But the laws themselves, and many of them could be, some of these laws we're talking about can be 2,000 to 5,000 pages. And of course, they have way more than just maybe federal regulation of healthcare. But it's the agencies, the administrative agencies' jobs that are under the executive branch to go out there and say, okay, you guys just passed this big old long law. We've now got to sift through it, figure out what it is that you're really saying that we have to do, and figure out how do we do this either with current rules and regulations or do we need new rules and regulations. And that's what those administrative agencies under the executive branch do. Same thing on a state level. Medicaid is a joint federal-state venture. The feds put in half the money, the states put in half the money, and Medicaid is run by the states. So the state, again, gets laws, and some of them are brought up by the state legislature. And then the agencies, the administrative agencies under the governor's office, then have to figure out, okay, we've got either this federal rule coming in or this state rule coming in that we're going to have to implement. Remember, they don't create them and they don't pass them. Their job is to implement them, make them happen through rules and regulations. And that's how that goes. Legislative branch, they are the ones responsible for enacting laws in the form of statutes. Our government organization model is two chambers, a Senate and a House of Representatives. And again, this really goes back to a lot of middle school stuff we all learned. So I'm not going to go into detail with that, just except to remind you that the legislator is the one who creates and passes, essentially enacts the law in form of statutes. Then the law heads over to the administrative branch, who has to then sift through and figure out, okay, how do we implement this law and make it happen? And then you get to the judicial branch, which, let's say this law passes, and the legislature, whether you're talking on a state level or federal level, they pass a big law, and then it goes to whoever is the executive branch, whether that's the governor on a state level or the president on the federal level, and then it goes down to their agencies, their administrative agencies, who figure out the rules and regs. They go ahead and put those into place. After they get put into place, people or companies or even agencies within the government can say, we've got some issues here. We've got some conflicts, or we've got some things that maybe are something that we're concerned about maybe doesn't follow the Constitution. That's when it gets kicked over to the judicial branch, whether you're talking on a state level or a federal level. The judicial branch is the one that takes these conflicts or these arguments or these disagreements or what have you, and they sift through it and figure out, okay, based on either the state constitution or the federal constitution, depending on, again, whether you're talking federal or state, what is going on. And it says that they apply res judicata, a matter already judged. So again, if common law is there, they're going to go with it. If something has already been judged and interpreted and accepted, they're going to go with that. They're not going to pick up the case and rehash over it. But if it's something that they don't believe has been interpreted and adjudicated in a lower court or through common law, then they may consider and pick it up and go for it. Maybe it's an aspect of the law that no one's argued before in another court, or they've argued in another court and it's gone back and forth and it's been very contentious. So it just depends. The reason why we have three branches of governments is to separate powers, to limit the authority of each one and have each branch kind of do checks and balances with the other. That's the ideal. That's the theory behind it. I'm not going to get into reality. I'm not going to get into politics, and I would ask also that as you go through this course that you set that aside. What we want to do is learn the facts, and we want to learn the theory that we need to know for the legal knowledge we need to know as it relates to health information technology. So that's where I'm going with all of this, is just keeping our focus where it needs to be, which is on the academics. All right, so we talked about state court systems. Typically they have trial courts. That's the lowest tier in a state. They have general jurisdiction or limited jurisdiction, depending on what they are and what they're dealing with. You have appellate courts, that's a middle tier. So let's say you take a case to a trial court. If the person who has the judgment against them disagrees, they can say, I'm going to appeal this. I'm going to appeal this to the appellate court. So they're the ones that are going to hear appeals on the final judgments of state trial courts. So you can go to trial. If you don't agree with the verdict, you can take it to the appellate court. They can either turn it down or they can agree to hear it. Most of the time, they agree to hear it, unless there's some type of common law, again, or previous judgment, or unless it's a really cut and dried, open shut case. Typically, appellate courts will hear it, but if it's already been determined in many other ways and there's nothing that went wrong with how the case was presented, if it was a jury case, if there was no tampering with the jury or anything like that, or any conflict of interest by the judge, they may choose not to hear it. And then once you get through the appellate court system, let's say you as the individual didn't agree with their judgment, and you're like, well, I'm not happy with the appellate court's decision. I want to have it heard again. That's where you appeal to the Supreme Court, the state Supreme Court, and they're the ones that hear the appeals from the appellate courts. Or if there was no appellate court to hear the trial court, it goes directly from the trial to the state Supreme Court. It just depends on the state, because some states don't do an appellate court. They charge their state Supreme Court as the appellate court, so to speak. So you have that progression between trial, appellate, and supreme. All right, federal courts. You have district courts throughout the U.S., and that might be a fun Google activity at some point, is to go out and Google all the district courts, or at least the ones that are closest to us here in Iowa, just to be aware of those. And again, circuit courts. These are the appellate versions. So you go first to district, then to circuit. And then the U.S. Supreme Court is the final decision maker. And again, they turn down a lot of cases, the U.S. Supreme Court does. The amount of cases that they actually agree to hear are very small. Because usually by the time a case gets to the Supreme Court, it's been through it's been through district and circuit courts, and they've, again, really sifted through to see, are there any prior decisions? Is this something that really has to involve the Constitution and things like that? So there's there's very few cases that get to the U.S. Supreme Court. Jurisdiction, that's the legal authority that a body possesses to make decisions. So courts have jurisdictions, the legal authority to make decisions. There's two types of jurisdiction when it comes to federal court. There's subject matter and there's diversity. So for instance, subject matter means that in order to get to a federal court, it has to be related to federal law or the U.S. Constitution. And diversity jurisdiction means you're dealing with different states that are involved in something that pertains to federal law or the Constitution. This talks about non-legal entities. They're voluntary, don't have legal authority, but they are powerful and influential. Some that we have talked about. Do you see some familiar names here? How about Joint Commission? These are all accreditation agencies. And these accrediting bodies, they don't have legal authority, but they're able to, on behalf of the government, they have a contract with the government to go out on the government's behalf to accredit organizations. And at that time, they can impose their sort of judgments on the organization. So they're not a part of the legal system in terms of being like a court or a judge or anything like that, but they have been given some authority through a contract with the federal government when it comes to accrediting. Alternate dispute resolution. There are lots of ways that disputes can be resolved. In the last 25 years, there has been a huge push to try and get them out of the legal system, out of the court system, and into something else because it takes so much time, so much money, and clogs up the court when they're doing dispute resolution. And so you may hear about arbitration or mediation. These are two concepts that they have tried to promote over the last 25 years to get dispute resolutions out of the court system. To still get resolution and for it to still be binding, but to do it without using a courtroom and a judge. So you've got the definition here for arbitration and as well as mediation. Most contracts these days talk about arbitration or mediation rather than going to court. So for instance, when I was involved in drafting contracts for release of information services, for microfilming, microfiching services, for scanning, imaging services, for contract coding, and for a variety of other things, transcription services and things like that. When I did those contracts, I had a standard contract from my organization, from the general counsel at my organization, and it already had the organization's verbiage for arbitration and mediation. All right, that is it for Chapter 3. Hope you found this interesting and look forward to talking to you soon about Chapter 4. Take care.